Hi everyone, Rod Armanda, immigration and personal injury attorney, making this video to go over a recent announcement by the Biden administration. On June 18th, they announced that there would be something that's called basically being called Biden PIP, which is parole in place. We have something similar for military members, which is parole in place. It's for people who haven't been admitted or paroled into the United States when they entered, so they entered without permission. So what this parole in place is designed to do is basically correct that problem and basically have them be paroled so that they can adjust for status if they're otherwise eligible. USCIS has recently announced that they're accepting these applications starting August 19th, so coming up in about a week or so. DHS what they're going to do is they're going to consider these applicants on a case-by-case basis for non-citizen spouses and also stepchildren of United States citizens. So what is a stepchild of United States citizen? It means basically the United States citizen married the parent of the child before the child turned 18 years old to be considered a stepchild of that United States citizen. So some things to consider that they've listed out for requirements. Of course, all this stuff's going to get, unfold more, and we're going to learn more about this because it's a new program. But this is going to apply to people, again, spouses of United States citizens or children of United States citizens who have lived in the United States for 10 years. They do not pose a threat to public safety or national security, are otherwise eligible for adjustment of status. There's a bunch of other requirements. And they also merit what they call a favorable exercise of discretion. So that's going to leave room for other things to consider in your background, such as immigration history, criminal history, the results of your background check for national security and public safety concerns. But if you are eligible, again, you would be basically able to adjust for status. The DHS estimates that there's about 500,000 people who are going to qualify for this program as spouses of United States citizens, 500,000 non-citizens, and there will be about 50,000 non-citizen stepchildren of United States citizens. So this is a big announcement. It's going to affect a lot of people. It could help out a lot of people. Again, you have to be, more specifically, again, you have to be present here without being admitted or paroled. So basically, you didn't enter with a visa, you didn't enter with permission, a border crossing card, you were not paroled, and you have been continuously present in the United States since June 17th, 2024, for a period of 10 years. And so that cutoff is June 17th, 2024. And then you have to also have a legally valid marriage as of that date, same day, June 17th, 2024. Now, what's, again, great about this is that there's a lot of people who weren't admitted or paroled, but they are married to United States citizens. So what are they doing if they're eligible? They can show extreme hardship. They've filed a lot of waivers for that unlawful presence, but they have to leave the country after that waiver is approved. The great thing about this program is that it's going to allow people to stay in the United States and have their application adjudicated inside the United States. They don't have to leave the country. And then another thing with these waivers is it's taking approximately 5 to 6 years, even sometimes longer, for the waiver to be adjudicated and receive an approval for it. So you're waiting for that whole time to get an approval. Once you get an approval, then you have to leave the country and do an interview abroad with a consular process officer who has unfettered discretion. An attorney can't go to the interview with you, unlike here in the United States where an attorney can go to the interview with you. You're going to be dealing with USCIS officers that can be checked by basically an attorney, or they don't have unfettered discretion. So if they do anything that is unreasonable or arbitrary, it can be more easily challenged by an attorney for you. So there's a lot of advantages to this program. If you are eligible for this, make sure you reach out to an attorney and talk to them. But be careful, because just like DACA and DAPA, we expect that this announcement, this program will be challenged in courts, like in Texas and other places, and it might be stopped, just like the acceptance of new applications for DACA. So be careful of any attorney promising you anything, because definitely no attorney can promise that they can get this done for you. But hey, we can certainly apply for it, and you should if you're eligible for it, and hopefully you're able to get it, because it has a lot of advantages.